pictures. Okay, thanks Verda, and hello everyone. I'm happy to be here today to share with you some work in progress on animal powers in continental law. And I wanted to start with a short introduction about this monkey. Some of you may have seen some pictures of this monkey appearing in the newspaper because he made in the international news when in 2012 he was found in an IKEA, and he had escaped from his owner, who kept him as a pet, and was brought to a sanctuary where he was taken care of. The sanctuary, however, refused to give the monkey back to his owner. So the owner, who was called Nakuda, she started a case about the monkey to claim it back. And interestingly, the court decided that by escaping, the monkey essentially had terminated the ownership of the owner over the monkey. So when Mrs. Nakuda lost possession of the monkey, she also lost ownership of him, the court stated. And in this judgment, which is really an interesting read, the court applied several Roman law, very ancient doctrines of property law. For instance, it went on to discuss the idea of Animus revertendi, which was found already in Roman law, and it institutes the idea that when animals have a habit of returning, you won't lose ownership rights over them because they will still be regarded as your property. And it concluded that in this case the monkey Darwin did not have a habit of returning, and therefore the ownership was lost. Eventually it also, this very old doctrine that animals are ours for as long as they are governed by our control, but when they escape from our custody and return to their natural state of freedom, they cease to be ours. I think this is an interesting case because it really shows that sometimes actions of animals can have direct legal consequences. And that is what I really want to dive in with this paper, is in the question, when do acts of animals have direct legal consequences? When can an animal, through doing something, certainly cause a certain legal change? And there I'm interested in consequences that are different from inanimate, so non-animal events, such as, for instance, a hurricane, because my property may also be destroyed by a hurricane, but that's not what I'm interested in here. I'm interested in consequences that are connected to the special nature of animals as living beings. Apart from that, I'm also not a philosopher that wants to establish whether or not animals have a certain agency or not. I'm really looking at the law, so the legal responses to animal action, and not so much on the question, do animals have agency? With this paper, I then build on existing scholarship that increasingly moves away from the long-held assumption that animals are merely legal things, such as by visa. In my own work, I've also discussed this and argued this in works by Margot Michel. An idea that is also corroborated by the growing degree of derification, so the fact that in many jurisdictions today there's a clear legal distinction between legal things and animals, a kind of a third category, you could say. So the focus of my paper is on continental civil law, as most of my work, so not the Anglo-American systems, but primarily continental Europe. And then for this paper, I focus on the Netherlands, which is my home jurisdiction. So I'll say very shortly something about the theoretical framework. How do I understand this notion of legal consequence through an act? Then I'll discuss 4 case studies to see at this point primarily an exploration to see, okay, are these situations in which animals cause some legal consequences? And then I'll end with some general conclusions and discussion. So this is for many of you probably a familiar graph, the Hoffeldian framework of jural relations, fundamental legal conceptions. That is a very fundamental theory in private law, in law in general, and it kind of made its way into animal law largely thanks to Visa's work. And was increasingly used to explain the legal relations in which also animals participate. And I don't have time to really explain the contents of the theory, but until now the main focus has laid on the first part, so the right-duty relationship, the idea that perhaps animals already have some rights because there are duties in our current legal systems towards animals. And this is an idea that was developed by Visa, but also Saskia Stuckey, who have argued that by applying Hofeldian theory of legal relations, you can essentially argue, you can find rights already on behalf of animals that are essentially the other side of the coin of a duty towards animals. So for this paper, I'm more interested in the other side of the scheme, so the power-liability relation. And this is less discussed in animal law, but the article that was already referred to in the previous presentation, the argument that we need an agency turn in animal law, moving away from only seeing animals as passive participants of protection, but rather seeing them also as agents in law. And that is what I want to do here, so I will focus on the notion of the power and liability. So what is a power? What is a Hofeldian power? Now, very shortly, Hoveld defined it as such. It can be identified when a change in a given legal relation results from some superadded fact or group of facts which are under the volitional control of a person. And that person is maybe said to have the legal power to effect a particular change of legal relations. Now, Hoveld, of course, never really explicitly aimed to apply this theory also to animals. He really spoke about persons, and he would probably not, well, we can't really know, but his main focus was not on animals. But people like Visa have extended this notion, and also with regard to powers, argue that it can be applied to animals, and it essentially consists in the ability to cause changes in legal relations through volitional conduct. And importantly, it is not really necessary for something to be a power for the person to have an intention to cause that legal change. So you can also have a power without the intention to actually make a certain legal consequence happen. It is sufficient that one's conduct causes the change, as Visa put it. So we are speaking here of volitional conduct, and that is a clear requirement in the Hofeldian framework. Actions must be willed or voluntary. They are just not automatic or reflexive. So there is some threshold, essentially, for an action to be regarded a volitional action. And then also importantly, power necessarily corresponds to a liability on the part of someone else, or on the part of the person themselves, that is liable to have their legal relations changed. So the main example that is often given is that of a landlord who holds the power to terminate a lease, and a tenant that holds liability to have their lease terminated. So if we then apply the Hofeldian framework to animals, we can say that an animal holds such power when it's voluntary, so not reflexive or automatic, but it's voluntary behavior, conduct. Even it doesn't need to actually intend to cause a legal change, but it does bring about a change in a legal relation. Another party has the corresponding liability, so their legal position is subject to being altered by that conduct. So one clear situation that I mentioned as an introduction is that of animal escape. The situation here, an animal escapes captivity, has a legal consequence, namely the ownership is terminated. And the ground for that differs, and of course the specifics will differ per jurisdiction we look at, but in many continental jurisdictions there is still some basis of this Roman law in the civil code or in the property law context. So in the Netherlands we find almost literally, maybe I'm in the front, but almost literally the Roman law doctrine that was mentioned. So Article 19 of Book 5 states that the owner of tame animals loses ownership when, after having escaped, they have become feral and the owner of other animals loses ownership when they gain their freedom. The owner does not immediately attempt to recapture them. So here I think we clearly have to do with a volitional action. I would argue that an intention of the animal is to escape, it's the purpose of the act. It's not an automatic or reflexive act. It is clearly something else. It's an intentional conduct. And you see also a clear liability on the part of the owner who loses ownership of the animal. And arguably also a liability on the part of everyone to gain a liberty to take ownership of the animal, which is returned to its free state. So here I think we have quite a clear example of an animal power, essentially. A second situation I want to discuss is that of animals causing damage. And when an animal causes damage to a person or property, there is also a clear legal consequence. A liability arises on the part of the owner. And again, to take the example of the Netherlands, which is a very clear example because there in the civil code, it is also through case law made clear that the action of an animal that causes damage needs to be the result of the own independent energy of an animal. So it is clear through case law that, for instance, when an animal infects other animals with a sickness that contaminates or infects other animals, then it's not the result of the independent act of the animal, so the keeper of an animal will not be found liable. And the same, there was damage caused by a cow that did not display any unexpected or unpredictable behavior, part of a guided health that falls also outside of the scope of this article. So again, here you see a clear attention in the law for the own energy, the independent act of an animal as kind of a determining factor for liability to arise. So is this a volitional act? Well, that is questionable. In many jurisdictions, there's not this requirement of the own energy, and a keeper will simply be liable for whatever kind of damage is caused by an animal. So often it will be automatic or reflexive, which perhaps you could see it as a quasi-volitional power, but it is still clearly an independent and animate act, which is different from, for instance, a thing that is property. The liability is borne by the owner to be liable, because I think we need to distinguish here between the Hoffeldian liability and being liable. So it's a Hoffeldian liability to be liable and gain a duty to compensate the injured party, and a liability of the injured party to gain a power to demand compensation. So again, here I think we see some clear, especially in the Netherlands, legal consequence that is attached to the behavior of an animal. It's still a bit debatable whether it's a fully volitional conduct or whether it's a bit quasi-volitional, for instance. Then a third situation I would like to look at is that of an endangered animal crossing a border. So an animal that is listed on supranational instrument as being an endangered animal also sets about the legal consequence, because when it enters a new country, it essentially has the result that the competent authorities are under an obligation to bring in place a system of strict protection. The ground for this is, well, Habitats Directive if we're talking about mammals, but for instance the Birds Directive if we're talking about birds, that stipulates that member states need to take measures to establish a system of strict protection as soon as an individual of this species is on their territory. So here, are we talking about a volitional act? I think that's rather questionable. It's probably not really the purpose of an animal to cross a border. So again, maybe perhaps it's more of a quasi-volitional power. And what you could also argue is that the same is true for plants if they move into another territory. So there, you wouldn't really speak of an act in itself. So this is a bit of a border case, I would say. The liability, if we do see it as a power, is on the part of the competent government authority to bring in place a regime of strict protection. Then the last situation, okay. I want to look at animals getting sick, because here as well it can have a direct legal consequence of creating a duty of care to an animal owner. For instance, we look at animal welfare law in the Netherlands. There is this clear obligation: the person who keeps an animal shall ensure that the animal that appears sick or injured is immediately cared for in an appropriate manner. So there's also case law that demonstrates that if you don't take action immediately, that can be a form of animal abuse. So is this volitional? No, clearly not. It is essentially passive change in the state of the animal, so it's not really an act. But still, I wanted to include it here because I think it's an interesting difference with, for instance, the ownership of a table or legal things where there won't be suddenly a duty arising from the change in state of the thing. And if we then regard it as some form of power, a very passive power, then the liability would be either borne by the owner, and in some cases by everyone, as in the Dutch Animal Protection Act. There's also a general duty of care of everyone to help an animal that is in an emergency. So, but as I said, it's arguably not a power because it's not really an act. It's not volitional of an animal to become sick. But then, based on this exploration of some examples, which are not exhaustive at all, it's just a selection of some situations that I think demonstrate this ability of animals to sometimes cause direct legal consequences. We can distinguish between volitional animal powers, quasi-volitional animal powers, and these passive animal powers, which is a bit a contradictio in terminus, so perhaps I should just erase this from the overview. And then these different categories are distinguished based on the amount of agency that the law essentially recognizes for animals. The most passive, the getting sick, would be totally on the low side. Crossing borders, perhaps a bit more quasi-volitional than causing damage. And then I think the animal escape in the Dutch context, for instance, is the best example of a volitional power in a Hoffeldian sense. So, to conclude, eventually, this is still an exploration because it's very much a work in progress, but eventually I would like to go towards more of an argument that some acts of animals do cause changes in legal relations, and animals can be said to hold some Hoffeldian powers corresponding to liabilities on the part of humans. And perhaps, but that's still very speculative, we could read this as the law implying that animals have some degree of agency. So this is, I think this paper is an exercise in what you could call analytical animal law, where you often get the response, but why would we apply Hofeld to animals? Like why is that even necessary? And I think Peter Schleck puts it very neatly by saying that this Hofeld's analysis opens up worlds of legal possibilities of choices to be made that we would otherwise pass by. And in this case, one of the trends that I think this way of looking at animal law contributes to is the one proposed by Lisa and Paulina in their article, to focus more on animals as active agents rather than only passive recipients of legal protection. So thanks for the attention, and I hope there's still some time.